All right, we're continuing our discussion of immigration reform during the Cold War years. And we had discussed how the 1952 McCarran-Walter Act, with that law, well, it was felt that not enough was being done to reform immigration laws because while it did get rid of the aliens ineligible for citizenship clause that stretched back to 1882 Chinese exclusion, it still did not repeal the national origins quota system. And we mentioned that with the success of policymakers, especially with the advent of immigration liberalism, you have this intent, increasing political pressure with the intention of undertaking more reform and overhaul. Now, another thing they wanted to do, besides repealing the national origins quota, was to advocate something called family reunification. And basically, this means that with all the immigrant history that happened since the 19th century, they wanted to allow spouses and children and other family members to be immigrants, to allow them to come as immigrants to the United States, and therefore lead to, again, reunification of the family. And needless to say, this was specifically aimed at European immigrants because, as we mentioned, close to 12 million immigrants came over during the Industrial Revolution into the 20th century from Southern Europe and Eastern Europe. So, again, this was the intention of policymakers. Now, let's discuss some influences, however, that are going to be directed at persons of color in this case. First of all, this is all happening during the Civil Rights Movement after World War II. And as we know, this is a movement to reform race within the country, specifically to dismantle Jim Crow. That's to say, de jure segregation, legal segregation, especially what's happening in southern states, not to mention customary discrimination and segregation happening elsewhere in the country. This was indeed the most important event in terms of social or domestic reform that's happening. And it's inescapably race based, needless to say, right? So, of course, you can see the connection here. Even though immigration laws are not directly connected to, let's say, Jim Crow laws in the South, it's still race based. Immigration laws are connected to skin color. All right. So it doesn't surprise us that during the civil rights movement, they'll also be thinking about immigration reform and eliminating those race based categories from our immigration laws. But one thing you cannot ignore here is that Cold War dimension. All right. Because as we've been discussing, the United States is amid this intense rivalry with the Soviet Union in attracting third world countries into its political orbit, right? The first world or the second world. And as we know, third world countries are comprised of persons of darker skin. So, with America's open racism in its policy, in its laws against persons of darker skin, such as Jim Crow segregation, such as our immigration laws, well, as you can easily imagine, this served as a very effective ideological weapon employed by the USSR, the Soviet Union, basically calling out the United States as being racist, that its institutions were just suffused with racism and discrimination, and basically calling the United States hypocrites. They espoused to be the standard bearers of freedom and democracy, yet that did not apply to their own persons of color within the country. So again, the United States felt that it needed to improve its global image due to this effective propaganda that was emanating from the USSR. Okay, so you can't ignore that dimension when we are discussing the reform of immigration laws. And this aligns perfectly with the prevailing political attitude towards race during the 1960s, which is called racial liberalism. And basically, racial liberalism refers to the status quo during the 50s and 60s, which was basically liberalism, okay? And how they felt that the government, the federal government, had a duty to reform, to get involved in race-based issues in the country rather than, leave it up to the states, right? So this is called racial liberalism, but you cannot untether that political attitude from the Cold War. Because again, these contradictions between, racial discrimination and democracy, well, it was exploited by the USSR to win influence among those newly decolonizing nations in Africa, in Asia, in the Middle East. We were losing that contest to win those nations. Therefore, the U.S. needed to address racial injustice to strengthen its credibility during the Cold War. So, again, you align that pragmatic approach with the Cold War, okay, and that again becomes the status quo position towards policymaking for race-based issues, racial issues. Okay, so all these things together, they serve as a constellation of influences leading to this movement to overhaul the immigration laws. Okay, and this would culminate with the 1965 Immigration Act, also known as the Hart and Celler Act, because these are the two senators that sponsored the bill, Senator Hart and Senator Celler. Okay, so again, the aim here among congresspersons was to abolish the national origins quota system, right? To abolish that as the basis of American immigration legislation, and at the same time to promote family reunification for those families in the United States that have a, history of immigration. So the liberals in Congress successfully pushed through a bill that served as this very radical departure, right, of our previous immigration laws, all right? And it would lead to, again, the repeal of the national origins quota finally, right? Now, what about nativists at this time? Surely there are nativists around that are very concerned about the fact that the national origins quota is going to be repealed. So to appease the nativists, to placate them, lawmakers argued that family reunification, that provision that would be part of the 1965 Immigration Act, would be pursued primarily by European citizens, that is to say, Americans of European descent, and specifically American citizens of Southern European and Eastern European descent. All right, it would not be pursued primarily by Asians in the United States. Let's remember, as I mentioned earlier, Asians were much less than 1% of the population, right? So even if they did pursue family reunification, even if you eliminate quotas, right, of these immigrants coming from Asian countries, it would barely make a dent in the entire American population at that time. That was the reasoning. Okay, so again, the architects of the 1965 Immigration Act firmly believed that family reunification amendments in this new law would primarily benefit immigrants from Eastern and Southern Europe. That is to say, Jews, Italians, Greeks, and so forth. It was reasoned that Asians in the United States at that time were simply too small in number, and even upon petitioning family members for reunification, there would be no significant or appreciable increase of the overall percentage of Asians coming to the United States. Okay, so in other words, they were assured, nativists that is, were assured that Asians would not change the racial complexion of America, even though this new law would replace the national origins quota system. Okay, so here is a quote that was given by a speech maker for the American Legion, which was a nativist group back then. And he's addressing his audience with the rationale as to why this new law would not lead to this precipitous increase of Asians coming into the United States. And this is what he says, quote, Asiatics having far fewer immediate family members in the United States than Southern Europeans will automatically arrive in far few numbers than Italians, Greeks, and other Southern European racial stock. There is no sting in the new law to offend Asian nations. Asians will qualify on the same basis as others, though far fewer of them will be able to do so, unquote. So that quote reflects basically what they were told, the nativists, right? That you don't have to worry about it. Asian populations will not rise in the United States significantly, even if we eliminate the national origins quota system. Okay, so when we look at the categories that are going to replace national origins quota, that was part of the 1924 Immigration Act, that's the question. What's going to replace national origins quota? Because that was basically the foundation of our immigration laws back then. Well, they'll be replaced by new categories, specifically family reunification, which we've been discussing. But also, you'll see categories connected to particular labor needs of the U.S. economy at that particular time. Now, when it comes to Asian immigration, what we'll see here is, finally, Asian professionals, the professional class, like, engineers, doctors, nurses, and what have you. Those laborers now allowed entry into the United States. But of course, you're still and always will have unskilled labor needs, whether it's today as we speak or going back to even the first African slaves, right? Okay, so this is what we'll see. And what we're going to witness by the time the 1965 immigration law passes is what I call this hierarchical preferential system. Let's take a look at that. So again, with the 1965 Immigration Act, we're going to see national origins quota replaced with these 7 categories. Okay, and as I mentioned, it connects to either family reunification or to labor needs. And another part of this law was the Cold War. Okay, so number 1 is obviously family reunification. And by the way, as I mentioned, they're preferential categories, meaning this is given first priority, any given year. And then it goes down the line to number 7, right? So the first priority is upon category 1, which is unmarried children of U.S. citizens under the age of 21, okay? Notice it says citizens here. Number 2, it says spouses and unmarried children of permanent residents. So here it's residents rather than citizens. Number 3 relates to Cold War and labor needs, okay? Professionals, scientists, and artists of exceptional ability. That's to say, we wanted to attract the, quote, best and brightest from other countries to our country rather than the Soviet Union, right? Number 4 is obviously family reunification, married children of the age of 21 of U.S. citizens. So you have the children and their spouses, right? Number 5, siblings of U.S. citizens abroad, okay? 6 is labor. Workers, skilled and unskilled, in occupations for which labor is in short supply in the United States. And 7 is definitely Cold War, okay, refugees, those that are escaping political persecution from these communist countries. Well, you're welcome to come to the United States as refugees, okay? Again, Cold War context is inescapable for that one.